Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the case of the Queen and Kerr, and this is a case that was heavily requested. Usually when people have topic suggestions, they're around sort of an idea, but this is one that a lot of people have requested by case name, so I really wanted to cover it. It was a rare opportunity for the Supreme Court to address issues of self-defense and carrying a weapon for that purpose, and maybe offer some clarity to Canadians as to what the law is. Unfortunately, as you see, we don't get a whole lot of clarity out of this one. So I'm going to try to explain what's going on, sort of what happened in this case, and if I can't make it clear, at least hopefully explain why this decision is such a difficult one. So let's have a look at this case, and as mentioned, it's the case of the Queen and Kerr from 2004. So the first thing I'm going to mention here is that when you see the number of justices, we've got Major, Bastarache, Binney, Arbour, Labelle, Deschamps, and Fish. So 7 justices, and there's a reason why there's an odd number of justices that sit typically, and that's because they don't want tied decisions. They don't want it where, 3 justices say one thing and 3 justices say another, and, how do you sort that out? So they pick an odd number specifically to avoid that possibility. If in theory you'll get like a 4-3 split, and then at least you've got some clarity as to what the law is. Unfortunately, that doesn't work out in this case. And the reason why is we'll see when we start looking at the split of reasons here. So we see the holding is with 1 justice dissenting is that the appeal should be allowed, and we'll get to the reasons on that. But the sets of reasons. So first, we've got Major and Bastarache offering 1 reason, so we're up to 1. And then we've got the next one is Arbour and Labelle, so we're up to 2 sets of reasons. The next one, Deschamps and Fish, so we're up to 3 sets of reasons. And then we've got Justice Binney, who's dissenting, so we're up to 4 sets of reasons. So 1 case and 4 different takes on how this case should have resolved in terms of what the law is. And many of them are 2 justices. There's 3 decisions that are each 2 justices. So it's really hard to determine which view is the correct view of the law after all of this. That clarity that I was talking about, we don't really get it here. All right, let's look at the circumstances because this is a bit of an interesting one. And so we're going to look starting with the decision or the reasons from Justices Major and Bastarache. So introduction. The appellant, Kerr, an inmate at the Edmonton institution, and I'll just stop here to say nobody in this is going to be somebody who's sort of clothed in righteousness. Everyone involved is to some extent unsavory. Mr. Kerr was serving, if I recall correctly, a 6-year sentence for armed robbery and other offenses. So not necessarily a Boy Scout, but that doesn't mean that we don't have to, or that we can't have any sort of sympathy for the predicament that he finds himself in here. And similarly, it's important to remember that in terms of rights and important legal issues, a lot of them are determined by looking at people who are unsavory. The rights of the common person end up getting fought over in contexts like this. So that's why I'd say, don't just say, oh, well, who cares what happens to this guy? He's, a bad dude. It's because it matters to everyone else. So let's have a look, when you see what his circumstances were, there's some reasons to be sympathetic to his particular scenario here. So he was charged with second-degree murder and possession of a weapon for purposes dangerous to the public peace. The deceased, Joseph Guerin, was a member of a criminal gang called the Indian Posse, which, according to expert evidence, controlled the institution at the time of the incident giving rise to the accusations. Guerin and an associate both had issued threats against Kerr. The trial judge found Kerr not guilty of the charge of murder on the basis of self-defense. This finding was upheld by the Court of Appeal. The trial judge also found Kerr not guilty of the charge of possession of a weapon for purposes dangerous to the public peace, but the Court of Appeal set aside the acquittal and substituted a conviction. So at trial, he was acquitted of both the weapons charge and the murder charge, and the Court of Appeal said, you know what, we agree with you on the murder, but we think you should be convicted on the weapons charge. You shouldn't have had a weapon. Notwithstanding the fact that the murder, the reason for the acquittal was a self-defense reason, right? It was found that he was defending himself lawfully in that circumstance. So the issue before this court is whether the Court of Appeal exceeded its jurisdiction by allowing the appeal. And that one's going to be interesting, and especially because I'm suspecting that a lot of my American viewers right now are going, what the hell? He was acquitted and then they got to appeal that? Yeah, there's limits to that in Canada, but they do allow appeals from acquittals. So, and whether, assuming it had jurisdiction, the convictions should stand. In particular, on the second issue, this court must determine whether defensive purpose is, and if so, in what circumstances, a purpose dangerous to the public peace. So that's a big issue for a lot of people because a lot of people often are concerned. I get a lot of people asking, saying like, listen, I live in a real bad neighborhood. Maybe, you know, I'm a woman who has to walk home alone late at night. Maybe they've had people follow them and make threatening comments, and they say, what can I do to protect myself? Well, we'll see how the court kind of tackles that issue. And the different justices have all sorts of different takes on that. So, facts. Both the appellant, Mr. Kerr, and the deceased, Mr. Guerin, were at all relevant times inmates at the Edmonton Institution, a federal maximum security jail. Guerin was a member of the Indian Posse, a gang which exerted control over the other inmates and the institution at large through intimidation and assault. So being in maximum security prison is not a fun experience. Yeah. Kerr worked at the institution as servery cleaner. On the evening of January 15th, 2000, Guerin demanded coffee from Mr. Kerr, but Kerr refused to provide it. Guerin told Kerr that if he were not provided with coffee, the prison guard would later find Mr. Kerr with his head smashed in. So this is a robbery. He's being robbed, but he doesn't provide this coffee. Later, another inmate, also a member of the Indian Posse, similarly demanded coffee and told Kerr that if he were not provided with coffee, Kerr should not be around the next day. So, and, you know, he's working there as a cleaner. You know, this is a prison job. So he's just working sort of at their cafeteria or where the food goes out. So the following morning, Mr. Kerr, as part of his duties as servery cleaner, set up the dining area for breakfast. Anticipating an attack, because of course he's been told that they're going to take him out, he retrieved two weapons which he had hidden under a sink. A metal knife, which he had manufactured by sharpening a big spoon, and an ice pick, which he had manufactured by sharpening a steel rod. So, a pair of shivs, or shanks, as they're often described in this particular case. So he concealed the weapons in his pants and remained vigilant as various prisoners entered the dining area. You know, he thinks he's going to get killed, so he's armed himself with these improvised, homemade weapons. Guerin, as well as other members of the Indian Posse, entered the dining area. Guerin told Kerr that he had punked him off. Kerr replied, whatever. The door to the dining area was then closed, and Guerin approached Kerr, brandishing a homemade knife. Kerr then retrieved his own metal knife. A physical altercation ensued, during which each stabbed the other multiple times. So they're having a knife fight. And when you're getting into a knife fight like this, the winner goes to the hospital, the loser goes to the morgue, and the winner often dies anyway, because often these are fights with very thin, pointed instruments that can do a lot of damage to organs, but don't necessarily have a lot of sort of stopping power. So people can be dead and still fighting and killing the other in the course of these altercations. They're really, you don't want to be in a fight like this. So, anyway, they each stabbed the other multiple times. At some point, Guerin jumped back and shrugged as though the fight were over. He began to walk out of the dining area, but collapsed. So he was able to say, listen, you know, we're done, we're good, but he was already dead. So Guerin was transported to the Royal Alexandra Hospital and pronounced dead later that morning. He died of a stab wound to the head delivered by Mr. Kerr during the altercation. Kerr was charged on July 9th, 2001 with the second-degree murder of Guerin, contrary to the criminal code, and with possession of a weapon for a purpose dangerous to the public peace, contrary to Section 88, Sub 1 of the criminal code. So basically, two prisoners get into a shiv fight, one of them dies, the other one's getting charged, right? That just makes, that's not terribly surprising here. But he goes and runs a trial, and we hear Claxon, so Justice Claxon accepted Kerr's evidence to the effect that he was defending himself against what he perceived to be a lethal attack. Justice Claxon found that Kerr's evidence was compelling and consistent with the physical evidence at the scene and the observation of other witnesses. Justice Claxon acquitted Mr. Kerr on the charge of second-degree murder on the basis that his actions constituted self-defense. And it's really hard to think of a more specific kind of self-defense scenario. You upset a couple of gang members who are known for engaging in violence where you are, and where the sort of culture where you are is such that this insult of not giving them coffee is one that that they're going to answer with violence. And, they say that they're going to use violence against you, and then they do. It's really hard to get more clear than that. The judge found that Mr. Kerr believed that his life was threatened, and that his belief was perfectly justified at the time. I mean, do you think that it was justified? I kind of do, right? When this guy threatens your life and then later tries to kill you, seems like the belief was justified. So with regard to the charge of possession of a weapon for a purpose dangerous to the public peace, Justice Claxon found that, on the date in question, Mr. Kerr possessed the weapons in part as per his usual practice, and this is going to be important, that he was always carrying these weapons. That was a regular thing for him. And in part to prepare for defense against imminent aggression. The judge cited the case of the Queen and Nelson for the proposition that possession of a weapon for self-defense purposes does not necessarily render that possession lawful. Nevertheless, Justice Claxon acquitted Mr. Kerr on the charge in question on the basis that he possessed his weapons for purposes of deterrence and defense. And he said, given the violent atmosphere prevalent at the institution at the time, and the number of inmates with homemade weapons, it's my view that the weapons possessed by Mr. Kerr were not possessed contrary to Section 88(1) of the Criminal Code. Rather, it would seem that Mr. Kerr had his weapons, much like the world's superpowers have their weapons, to deter first strike and defend against it should it become necessary. It's kind of an interesting analogy. Are the world's superpowers kind of like people having a fight at a prison? That might actually be a more apt analogy than I think a lot of people would be comfortable with. So let's keep on here, because now they're going to talk about what happens at the Alberta Court of Appeal. So with regard to the charge of second-degree murder, the Court of Appeal found that there was ample evidence upon which the trial judge relied in finding that all of the elements of self-defense were made out, and that appellate interference was thus not warranted. So it sounds like the Crown wanted to get that conviction on the second-degree murder charge, but the Court of Appeal was like, nah, clearly not. As for the second charge, the court identified the essential issue as being whether weapons carried for strictly defensive purposes will support a conviction pursuant to Section 88. The court indicated that no single factor, including acquisition and possession of a weapon only for the purpose of self-defense, is determinative of the issue of guilt or innocence on a charge of possession of a weapon for a purpose dangerous to the public peace, citing again the case of the Queen and Nelson. The court observed that carrying a concealed weapon is a crime by virtue of Section 90 of the Code, and this is where their reasoning starts to get a little weird. I'm just going to warn you on that one. And found that Kerr's actions in concealing the weapons play a critical role in the analysis of dangerous purpose in this case. The court held that the dangerous purpose requirement of Section 88 is found in Section 90, since even if one's purpose is self-defense, concealment of a weapon is itself a crime, and the unlawful purpose is thereby made out. The court indicated that there's an arguable distinction between possession of a weapon for defensive purposes, for example in one's home where concealment is unnecessary, and possession of a weapon in a penitentiary setting. Concealment of a weapon in your home is unnecessary because people aren't in your home. I don't post on my front door what things I own that could be potentially a weapon. So that one's kind of weird. But the house itself provides some concealment. You can't tell from, the outside that, I got this thing in reach. This is not in reach because it's, there as a handy weapon. It's in reach because I've been using it in a number of videos, and so here it is. But from the outside of my house, you can't see it. So, yeah, I find that one to be a little strange, but it gets a little weirder. So the court found that had it been, and I suppose I should actually show you what I was showing there. So, yeah, just little, it would clearly be found to be a weapon in most, if you were carrying around at the mall. Not necessarily so in my house because its purpose is primarily decorative. But, yeah, regardless, I mean, you can't see it from outside the house. I'm not kind of brandishing it at the public by having it on a shelf. So the court found that it had been Kerr's intention to deter the apprehended attack, that had it been his intention to deter the apprehended attack, it was open to him to display his weapons to the deceased in a timely manner. The act of concealment, according to the court, rendered it more likely that there would be a breach of the peace. I'll read a little more and then I'll respond. So the court found that while concealment facilitated Mr. Kerr's counterattack, it also contributed to an already dangerous situation of which Kerr was fully aware. The decision to conceal, according to the court, evidenced Kerr's choice of reprisal over deterrence. Now, think about this one a little bit. Like, you're in a prison and, there's this tense thought. Well, he sees these guys and, is he supposed to display his weapon first? That kind of makes it seem like he's the aggressor, right? Not the defender. Normally, when you are defending, typically you're going to be producing your weapon second or in response to a threat. So their notion here that he could have revealed this also seems a little weird, because if he reveals the weapons and, the other side just goes, okay, then they can just have him sent off to the hole and his weapons taken away rather than anything else. I really don't. This seems a little strange to me, and just as a spoiler, it'll seem a little strange to some of the other justices as well, as they go. So the Court of Appeals reasoning here seems a little off. So for these reasons, the court held that it could not endorse the trial judge's suggestion that the prevalence of illegal concealed weapons in the prison system entitled Mr. Kerr to possess his weapons for self-defense. The court regarded the trial judge's reasoning as a recipe for anarchy in the prison setting, encouraging the proliferation of illegal homemade weapons, exacerbating an already violent atmosphere, and making it more likely that violent outbursts would result in grievous bodily harm or death. So they set aside the acquittal and substituted a conviction for possession of a weapon for purpose dangerous to the public peace. Of course, this prison had already basically fallen into anarchy from what we're hearing here from the reasons. So, the issue is just, can he defend himself against these threats? Now, they're going to look at some of the relevant statutory provisions. So this is bits of the criminal code. Section 88.1, which is the possession of a weapon for purposes dangerous to the public peace. Every person commits an offense who carries or possesses a weapon, an imitation of a weapon, a prohibited device, or any ammunition or prohibited ammunition for a purpose dangerous to the public peace, or for the purpose of committing an offense. And every person who commits an offense under subsection 1 either is guilty of an indictable offense if the Crown proceeds by indictment, because this is a hybrid offense. The Crown gets to choose whether they're going by indictment or summary conviction, and liable to a term of imprisonment for a term not exceeding 10 years. So no minimum, but a 10-year maximum if they proceed by indictment, or is guilty of an offense punishable on summary conviction. Now, keep in mind, the Crown here thought that that this guy had committed a murder. So how do you think they proceeded on this one? Do you think they went by summary conviction? No, they went indictable on this one. He was facing a sentence of up to 10 years. He wasn't going to get 10 years, but, I mean, we don't know what they actually would have sentenced him to. So it's, or at least I don't have that offhand. It might have been in some of the lower court decisions. And Section 90, which they refer to just in part because the Court of Appeal did, he wasn't actually charged with this offense. It's just being used to offer some context on the purpose as dangerous. So every person commits an offense who carries a weapon, prohibited device, or any prohibited ammunition concealed, unless the person is authorized under the Firearms Act to carry it concealed. And this one is a bit of an important one for this one, and it's a procedural section. It's not actually an offense. It's how the courts the rules of court kind of that are in the criminal code. So this is section 676. The Attorney General or counsel instructed by him for the purpose may appeal to the Court of Appeal against a judgment or verdict of acquittal or a verdict of not criminally responsible on account of mental disorder of a trial court in proceedings by indictment on any ground of appeal that involves a question of law alone. So what that means is the courts are like a trial courtroom has to deal with several questions. And sometimes it's not just, sometimes you actually split these decisions up. If it's a jury trial, then the justice is the one who is the arbiter of the law, of getting the law right, and the jury becomes the arbiter of getting the facts right. They have to address the facts of the case. And so you've got the trier of law, who's the justice, and the trier of fact, who's the jury. So you're dividing up those tasks. But it sounds like this was a justice alone trial, so no jury, which means that the justice was both evaluating the law and the facts. So because of this, you can get two different kinds of errors. So an error of law would be, for instance, if the justice said, listen, for second-degree murder, all that matters is that death happens, and it doesn't matter what the intention of the person was. That would be a mistake of law. That's a factually or a legally incorrect statement. Or they could make an error of fact. So let's say all the witnesses testify that, Mr. Kerr had 2 knives, and the justice finds that he had, no knives, clearly in contradiction of all of the witnesses. That would be a mistake of fact. The government can only appeal on the basis of, they can only appeal an acquittal on the basis of a mistake of law, even if the mistake of fact is real bad. So that's a limit on their power. All right, so issues. There's 2 issues raised in this appeal. The first is whether the Court of Appeal had jurisdiction to intervene. And so that's basically, are they stepping outside the question of, is this a mistake of law, and into the area of mistakes of fact? So this particular set of reasons says, they note, by virtue of section 676(1)(a) of the code, the jurisdiction of the Court of Appeal herein was limited to a question of law alone. The qualification of a question as one of law, fact, or mixed fact and law has presented many problems in the past. So on appellate decisions, it can often be really important to sort out whether a decision is one of, a legal issue strictly, or one of pure fact, or one that blends those 2 issues in some way. And the reason why is because each of those can actually attract a different appellate standard. But as we see in this case here, it can also attract a different question as to whether or not the government can appeal it at all. So that's going to be the first question. So this particular set of reasons says yes. And they say, first, the Court of Appeal was of the view that the determination that a person possessed a weapon for a purpose dangerous to the public peace requires the application of a hybrid subjective-objective test. The purpose of the accused is to be determined subjectively, and the dangerousness of said purpose is to be determined objectively. We'll sort of explain what that means as we go a little further. So, however, the trial judge then proceeded to apply a purely subjective test and concluded plainly that possession of weapons for purposes of deterrence and defense does not constitute possession for a purpose dangerous to the public peace. The trial judge considered the violent atmosphere prevalent at the institution and the high number of inmates with homemade weapons merely as the context illuminating Kerr's subjective purpose, which purpose it found to be deterrence and defense. On this basis alone, and without consideration of the objective dangerousness of Mr. Kerr's purpose, the trial judge acquitted. So, second, the Court of Appeal regarded the trial judgment as having established a rule with wide application, thereby raising a question of law. The trial judge ultimately concluded that a purpose to deter first strike and defend against it should it become necessary is not a purpose dangerous to the public peace, and the Court of Appeal viewed this conclusion as a principle of law having precedential value, so that might be a rule that would be followed by other courts. So, fair enough. I mean, I don't disagree with this reasoning as to the Court of Appeal being able to consider the question. So, carrying on here. They say, In any event, the Court of Appeal was entitled to consider this matter a question of law and thus had jurisdiction to intervene. Now, some of the other justices will point out that in intervening, they actually step in and part of their basis for intervening is that they find a very different view of the facts. And so this is kind of thorny. That said, this is not really the reason why I'm covering this case. So it's an interesting point, and it sort of explains at least part of the breakdown in terms of these decisions and the different reasons, but I'm going to move on to the other issues here. So in terms of possession of a weapon for a purpose dangerous to the public peace, and again, we're just on one set of reasons. There's several. So Section 85 requires proof of possession and proof that the purpose of that possession was one dangerous to the public peace. There must at some point in time be a meeting of those two elements. Generally, the purpose will have been formed prior to taking possession and will continue as possession is taken. But that's not always the case, and the court notes, on the purpose, I note first that a person's purpose may change during the time he possesses. I endorse the perspective of the Alberta Court of Appeal in the case of the Queen and Calder, which stated, although it is firmly established in law that the element of intent or mens rea must be present for there to be an offense, it does not necessarily follow that a person's initial intent when he takes possession of a weapon governs throughout his possession. A person's intent does not necessarily remain constant and may change to a dangerous intent even though the initial purpose in taking possession was not a dangerous one. And this makes sense, right? Let's play with an example. Let's say I take my shotgun and I go duck hunting. Duck hunting is not a purpose dangerous to the public peace. Assuming I've got, I have a license for the gun, I'm a proper firearms license. I've got, all of my hunting permissions and so forth in line. I've got a license for my licenses. Everything is good. But while I'm out duck hunting, and I'm hunting my spot, I see, Bob drives by. And I hate Bob because, Bob is the villain of a country song. He's taken my truck. He's taken my job. He's taken my dog. And I just decide, you know what? Today's the day I'm going to go confront Bob. And so now I stop duck hunting and I take my shotgun over and I shoot Bob. Well, at some point in this interaction, my purpose has changed from the lawful one of let's hunt some ducks to the unlawful one of let's go murder Bob. And, at that point, my possession of the shotgun becomes a possession for the purpose or for purposes dangerous to the public peace. If a police officer were to arrest me as I'm walking over to go, fight Bob and, get into this gunfight, they would properly, assuming the court found all of these facts, be able to get a conviction on that. All right. So they say there must be at some point a meeting of the elements of possession and of a purpose dangerous to the public peace. There is some confusion in the jurisprudence about the proper test to be applied in the determination of purpose. In my view, the correct approach, a hybrid subjective-objective test, so this is the view of, one of the sets of reasons, was adopted by the Ontario Court of Appeal in Nelson. By this approach, the trier of fact must first determine what was the accused person's purpose. This is a subjective determination. The trier of fact must then determine whether that purpose was in all the circumstances dangerous to the public peace. This is an objective determination. So every set of reasons really likes this Nelson decision, and they all disagree about what it means, which is just wonderful. This is the Supreme Court of Canada that can't really decide what Nelson means and what the legal issue is here. But you yourself, if you are in a situation of potential life and death, issues, you're supposed to have that sorted exactly correctly. And a mistake of law, is not a defense in those circumstances. All right, so they talk about this subjective, objective, determination here. And so what that gets to is, subjectively, my purpose for having, a particular implement, and I'll sort of grab the sword here again, might be that I plan to use this to cut apples. And, assuming that the court agrees that that's why I've got it, then they have to determine whether my cutting apples is a purpose dangerous to the public peace in all of the circumstances. And, they might say that it is if I'm not cutting my own apples, I'm looking at cutting, the neighbor's apples off his tree, and he doesn't want that. It's that might be a purpose dangerous to the public peace. It gets a little finicky in terms of this distinction here, but the critical place where this is going to come up is in terms of self-defense. Because, if you say I have this particular item just for the purposes of defending myself, then the court is going to ask the question of, well, was your goal of self-defense in the particular context where you were going to do it a purpose dangerous to the public peace? Because the court does not really like self-defense. Or at least they don't like the idea of people being ready to defend themselves. So Section 88 requires simply that the accused person have a purpose dangerous to the public peace. Thus, any purpose will do, so long as that purpose is in consequence dangerous to the public peace. As discussed by this court in the Queen and Hibbert, the term purpose is capable of two different meanings: purpose as intention or purpose as desire. So in that case, the court concluded that for the purposes of Section 21(1)b of the Code, the former definition should be adopted. A person who consciously performs an act knowing the consequences that will, with some degree of certainty, flow from it, intends those consequences or causes them on purpose, regardless of whether he or she desired them. So if I'm chasing after you with an axe, and I know that you're probably going to be afraid, when I chase after you with an axe, the court will take it as I intended to cause you fear. Even if I would prefer that you not be afraid of me chasing after you with the axe, possibly because you not being afraid would make it a lot easier for me to catch you with the axe and engage in violence. So that is sort of their distinction in terms of purpose versus desire. If I shoot at somebody, on the street, I know that they could die from this. And so they will take that as an intention, as a possible, intent. Whether or not I'm actually hoping that they die. I might just be hoping that they get paralyzed or suffer some other serious injury. You can sort of see the distinction there, if that makes any sense. So since the provision reads a purpose, the Crown is entitled to rely on any of the accused person's purposes, because you might have multiple purposes for something. You might be carrying a gun in case you see some ducks or some deer, but also you might think, if I see Bob, I'm going to shoot Bob too. In terms of the possession of that firearm for dangerous purposes, the fact that I might be looking for ducks at the same time that I'm looking for Bob, they can use the bad one to convict me. That's what that's saying. It is interesting to note that conceptually, the defense of self-defense is not something which one intends in the criminal law sense. A person who is attacked intends to assault the assailant. His motivation is self-protection or self-preservation. They're kind of splitting some hairs here, I think, but they say, for the purposes of the present analysis, the phrase defensive purpose refers to the intention to assault an aggressor using only as much force as is necessary to repel or thwart the attack. Yeah, a lot of people might be carrying weapons not intending to have to, they might be intending to have to use them, but not necessarily to actually assault the person with it. A lot of times, simply a display of an item is enough to stop an aggressor. I don't know. This one I kind of debate on. But I kind of see their point there in terms of motivation versus, the intention. But, somebody who's carrying a weapon for self-defense probably isn't wanting to use it in that sense. They're just kind of having to in the circumstances. So certainly the determination of an accused person's subjective purpose may involve consideration of objective indicia. So what this means here is that... just because somebody says that their purpose for something is one thing doesn't mean that the court necessarily has to accept it. So let's say, for example, it is well known that, going back to my previous example, everyone knows I hate Bob. And, this is something I've not made any secret of. I will tell anyone who will listen that I'm going to go after Bob. And so I kick down Bob's door and, am found in his house yelling angry things about Bob while holding a shotgun. And the police arrive, and then later at trial, I say, listen, I wasn't there to do anything improper. My purpose was that I was hunting ducks in Bob's house. And, obviously they're going to look at those considerations of the objective indicia and determine that my subjective purpose was not in fact duck hunting. It was actually Bob hunting. So that's what that means there in terms of the court's explanation here. So carrying on, they say, thus, it is not enough to find that the accused person possessed the weapon for a defensive purpose. The judge must then determine whether said purpose was in all the circumstances dangerous to the public peace. And this is where we're going to get into the court having disapproval of the notion of people being able to defend themselves. So these two propositions, that objective factors are relevant to determining subjective purpose, and that the dangerousness of a particular purpose is an objective standard, are sometimes conflated. Gee, I wonder why. Is it because this is confusing as heck? Yeah, no kidding. All right. So, for example, it is unclear in the Alberta Court of Appeal judgment in the present case what significance is to be attributed to Kerr having concealed his weapons. According to the court, the act of concealment rendered it more likely that there would be a breach of the peace, but also evidences the respondent's choice of reprisal over deterrence. Well, you know how you prevent, like Mr. Guerin could have avoided this confrontation by simply not trying to murder Mr. Kerr. That was an option open to him the whole time. Mr. Kerr didn't have the option of not having someone attempt to murder him. That wasn't, in his control. The plain language of Section 88 strongly supports employment of the objective standard for dangerousness. It is noteworthy in particular that the provision reads, for a purpose dangerous to the public peace, as opposed to, for example, for the purpose of causing danger to the public peace. In my view, these two phrases bear very different meanings. The former phrase, for a purpose dangerous to the public peace, requires that the purpose, whatever it may be dangerous to the public peace. On the other hand, the latter phrase, for the purpose of causing danger to the public peace, requires that the purpose specifically be that of causing danger to the public peace. And quite candidly, I think that the court is probably giving too much credit to the authors of the statute. But what we see in a lot of this analysis, and a lot of the analysis of statute, is that if it had been phrased the other way, they might have said, well, we know that their real meaning is the other thing. So the principles of statutory analysis that we get taught in law school have kind of fallen by the wayside in favor of this principle of sort of a holistic assessment that often tends to land towards the particular judge or justice's idea of what the law ought to be. So in this case, they're saying, well, we're going to rely very heavily on the wording, but the court doesn't always do that. And I find that once we sort of get into this kind of muddy area where the court isn't always interpreting things in sort of the same fashion, we enter into a question of, how much of this is the court sort of importing their personal feelings on what the law ought to be to effectively change the law. So that's a legal philosophy question that is probably way off topic here. So rather than wander too far, let's continue on. And I'm skipping over a whole lot of this decision as per usual to try to keep the time down. But as per usual, this is going to be a long one because we are only in, set of reasons 1. There's several more, and I'll cover those in less detail. So accordingly, all the results which a man appreciates will probably flow from his act are classifiable as purposes within the meaning of Section 1. And since the statute refers to any purpose, the prosecution is entitled to rely on any of them. The next question then is whether the selected purpose is prejudicial or not, and that question is, in my opinion, to be answered objectively. So, that was in the context of a law saying that you can't have a purpose prejudicial to the state. And so the distinction that they're drawing there was a spy saying, listen, my purpose was to make money for myself, which, the government doesn't care if I make money. But they're rejecting that in terms of this reasoning, and so the court's looking at that decision. So thus, the difficulty with the Nelson judgment and the cases which follow is not that it set out a hybrid subjective-objective test for the phrase "for a purpose dangerous to the public peace," but rather that it did not make absolutely clear what actually constitutes a danger to the public peace. So that's very unclear, and it's going to continue to be unclear going forward. This paucity in the case law is hardly surprising. There could be no exhaustive test for dangerousness because of the wide variety of settings and circumstances in which a danger may arise. While I'm prepared to accept, as proposed by Justice Binney, that public peace refers generally to a state of order or to the normal state of society, I am not prepared to hold. So at this point, because there's so many different sets of reasons, the justices are gonna kind of poke at each other, and they're going to poke at each other's reasons and basically say, this is why we can't agree. Because it's very weird that you get this many different takes on it. Normally, they'll try to come together so that they can draft, a clearer decision. The fact that they couldn't here means essentially that there was some judicial deadlock and that they just couldn't come to agreement on any of this stuff in some fairly critical ways. And yet, again, you and I on the street, we're supposed to know what the law is perfectly, even though the Supreme Court couldn't settle it out themselves. So they say, while I'm prepared to accept, as proposed by Justice Binney, that public peace refers generally to a state of order or to the normal state of society, I'm not prepared to hold, as suggested by Justice Binney, that violence is always and without exception a danger to the public peace. It is for the trier of fact, on the basis of all relevant factors, to determine whether the purposeful act would have, in the particular facts, endangered the public peace. Because Justice Binney, as we'll see, would have gone just absolutely wild with this in ways that I think most people would be upset by. So what is clear, however, is that the actual use of a weapon in a manner which is dangerous to the public peace does not establish that the weapon was possessed for a purpose dangerous to the public peace. Actual use is but one factor to be considered. So if you thought that things were getting unclear, well, they're getting even more unclear as we go. So in my view, the crucial issue in those cases where the accused person is found to have possessed a weapon for a defensive purpose is whether or not the attack which the accused purported to thwart was avoidable. So if you're thinking, hey, this means I can potentially carry a weapon for my... You're going to see how the court's going to narrow that. Thus, only where the attack is completely inescapable is possession of a weapon to thwart the attack, not possession for a purpose dangerous to the public peace. To the contrary, the purposeful act then constitutes an abatement of a danger to the public peace, namely an attack on oneself. Many indicia will be relevant to the determination of avoidability, including, inter alia, location, atmosphere, nature of the threat, imminence of the danger, and actual use. Now, when we start thinking about avoidability, we can think, just how far do we want to go here? If you walk home every night late at night because you work the closing shift at, your place of business, and it closes up at 2 a.m., you're out of there by 3 a.m., and you have to walk home. And let's say every night as you walk by, there's some creepy dude there who keeps making comments. Well, is the court going to say, well, you should walk a longer route home to avoid where that creepy dude is waiting for you? Or, let's say he adapts. Are they going to say you should quit your job? What if he's a stalker and pursues you to a new place of employment? Are they going to say, hey, listen, I know you live in British Columbia, but you should pack up and move to Quebec, and therefore you can avoid this guy who's potentially going to attack you? How far is this going to go? Well, we don't know. The one place where you can really get some certainty in terms of inescapable is prison, which is kind of weird. I mean, we actually end up with this weird rule that actually makes it more permissible to carry a weapon in a prison than, on the street where you've got some creepy guy stalking you and pursuing you every time you walk home late at night. I don't know if I think that's okay. Like, I don't know. And I will freely acknowledge this is a weird set of circumstances because, on one hand, Mr. Kerr is in potentially great danger, right? But on the other hand, you really don't want people having weapons at all in prison. It's a place where theoretically, weapons are contraband and should not be possessed at all. But is the solution really that Mr. Kerr should just get stabbed to death for not giving this guy coffee? Especially considering that he probably didn't have the authority to give the guy coffee. It's not like, Mr. Kerr's just sitting on a stash of spare coffee. It would have been him providing this in contravention of prison rules themselves. And as I mentioned earlier, that demand for the coffee is itself a criminal act, a robbery. Is he supposed to just accept that robbery as the means of avoiding this? It's a tough case. And tough cases make for some bad rulings and bad law. So, carrying on. So, in my view, one does not commit the offense with which we are concerned if one carries a weapon for self-defense that is an appropriate instrument with which to repel, in a lawful manner, the type of attack reasonably apprehended, and if the person carrying it is competent to handle the weapon and is likely to use it responsibly. In the absence of other circumstances, such as conduct calculated to provoke an attack, the purpose is unlikely to be dangerous to the public peace. That an attack might be repelled forcefully and even injured, or is not a danger to the section, or that the section refers to. In that case, it is the attack, not the response to it, that breaches the public peace. Which makes sense, right? Mr. Guerin had every option to not engage here. He chose to attack and to use lethal force. So that's on him. But, I don't really necessarily like all of this either. The person carrying it is competent to handle the weapon. Well, somebody who is normally an innocent, who isn't familiar with weapons, isn't inclined normally towards using weapons, and is therefore having to pick one up in circumstances of pressure, of danger, is that person really going to be held as, having it for purposes dangerous to the public peace? I feel like the court needs to grapple with this in a more substantial way than what they have been, and that the rule that they're relying on here needs to change, because you'll see as we go, there's one thing that they really want to avoid. And let's have a look at that. So they say, having a weapon for the sole purpose of abating a breach of the peace threatened to result from an attack on the possessor is not, in my opinion, a purpose dangerous to the public peace. Self-defense, justifiable under the code, is not confined to tooth and nail. And they add emphasis. There are tons and tons of cases in Canada where people have defended themselves using everything from knives to guns to, in some cases, vehicles, all sorts of potentially quite nasty weapons, and been acquitted on self-defense issues. But they say, in my view, a finding that the accused actually used his weapon in a manner which constituted justifiable self-defense is relevant under Section 88, but not sufficient for an acquittal thereunder. And, we can think of examples like this, right? Let's say somebody is out on the street and they've got a handgun illegally tucked into their pants, and they have no license for it. They have no registration certificate. They certainly don't have an authorization to carry or an authorization to transport. And the firearm is not in a case. It doesn't have a lock, doesn't have a trigger lock. It's loaded. All of the things that Canadian law doesn't like, because, of course, this guy's out there dealing drugs. Now, somebody comes out and, knowing that he's dealing drugs, concludes that he's in possession of drugs and potentially cash, and decides that they're going to kill him and take his stuff. So he uses the gun to defend himself in that circumstance. it's still a purpose dangerous to the public peace, because his purpose for having that gun is to defend himself in the course of, and to make it possible for him to engage in crimes. In that case, the appropriate thing is that he should have avoided that scenario by just not dealing drugs, not being involved in crime. But I think that's a very different scenario than somebody, a woman who carries some dog spray on her walk home, for example. Or at least it should be in the law, although it isn't really, as we'll see. However, it must be clear that whereas under self-defense, at issue is the accused person's conduct, at issue under Section 88 is the accused person's purpose. The accused may or may not have purported to use the weapon in the manner it was actually used, i.e. for a purely defensive purpose. Moreover, whereas under self-defense we are concerned with the reasonableness of the accused person's belief, under Section 88 we're concerned with the actual objective circumstances. Thus, a belief that one cannot otherwise preserve himself may be reasonable, yet in the circumstances simply wrong. So, they're saying that you have to worry about, the objective circumstances. So, this gets into some tricky, situations there, as to somebody saying, listen, I don't think I could have avoided this any other way, because I have to work at this, late, I have to walk home at 3 a.m., I have to, walk along this route because it's the quickest route to get home. And the court might say, no, listen, you should have said that you're going to refuse to do closings and you're only going to work in the mornings. And then that would have avoided any of the problems. And we think that that's the objectively reasonable way to avoid this. And therefore your carrying a weapon is not permissible. That opens us up to a lot of kind of after the fact reasoning, and a lot of self-defense cases are situations where people may not have necessarily made the best possible decisions. So, yeah. So having set out what I understand to be the applicable principles, I feel it is necessary to express some concerns with the approach adopted by Justice LaBelle. And I'm going to skip over a bunch here to just get to the heart of what really bothers these particular justices and their reasoning. So Justice LaBelle argues that Section 88(1) targets those who possess with the intention of doing harm to persons or property, or showing a reckless disregard for harm to persons or property. The difficulty is that the provision, understood in this way, simply would not capture the individual who carries a weapon regularly due to a generalized fear of attack, either because he lives in a dangerous neighborhood or because he is simply overcautious or paranoid. By Justice LaBelle's definition, this individual only commits the offense at issue on the day and the time when his specific intent to cause harm crystallizes, likely because an attack on his person will have become imminent or even will have already begun. Before this particular point in time, the individual does not intend to cause harm to any particular person. He intends only to prepare himself for a potentiality. Even broadening the mens rea element to encapsulate recklessness, as suggested by Justice LaBelle, will not, in my respectful view, sufficiently enlarge the scope of the offense so as to capture these individuals. It could be argued that concealing a knife in one's pant pocket, for example, does not in itself constitute a reckless disregard for harm to persons, since only if the knife is taken from the pocket and placed in the hand does there arise the risk that a person will be harmed. This is what they're afraid of, is they're afraid that the ordinary person who lives in a dangerous neighborhood might carry a weapon to protect themselves. And so the solution that the Supreme Court thinks, or at least that these two justices of the Supreme Court, is that they not carry the weapon and that they just experience this attack, which may have already begun, they talk about, and, do so unarmed and potentially helplessly, potentially without any ability to defend themselves. When we talk about self-defense, we say you have a right to defend yourself against a violent attack. If somebody wants to murder you, you have a right to, use force to repel that. But if you're 80 years old and you walk with a walker, you're probably not going to fight off, 3 healthy young guys. It's just not going to happen. I mean, even John Wick gets old someday and, loses the... So, but they're saying because you don't have a specific fear, you don't know exactly the guy who's going to attack you, and, you don't know exactly who it is, that you can't carry a weapon. So let's think a little bit about, who lives in these dangerous neighborhoods or these dangerous scenarios. Well, typically that is a situation experienced by the marginalized. You know, I've got some money. I'm able to live in in a neighborhood where I feel relatively safe. And in my occupation, I generally feel relatively safe, notwithstanding the fact that I do criminal defense. I, interact with, with bad people. Mr. Guerin wasn't a client of mine. He predates me being called to the bar, but he could have been, right? There's nothing that says that he couldn't have been, that guy couldn't have been sitting in an office with me at some point. But nevertheless, I feel relatively safe, and there have been very few instances where I've had sort of a realistic threat on, my safety. And I'll give a thank you shout out here to some members of the RCMP, as well as some of the sheriffs. I recently did have a bit of a more interesting day, and they were, there were some potential, comments about threat there, and they took very appropriate steps. They were very, it was appreciated. I am in a place where I can, where that's likely to happen. But let's say you're homeless. The homeless are subject to a disproportionate number of violent attacks, including robberies, and as well as just people who just want to hurt them. There are messed up people out there, and they tend to go after people who are vulnerable. If you're talking about people who, sex workers are more likely to be attacked. They may not have a specific person who's going to attack them, but, that's another group who might want to carry a weapon or have a weapon, at hand. There's all sorts of people out there who experience a higher likelihood of violence, and it may be for reasons that are entirely not their fault, or reasons that, when we deal with societies, or, and that can be, smaller sub-societies, smaller parts of Canada, if you're subject to bigotry and prejudice from people around you, because people don't like, how you live, or the color of your skin, or your religion, or whatever it is, you might fear that people are going to attack you over this. And that has been very much the case at points in history. This notion that means that you should just, I guess, suck it up and take a beating, in the words of, ADA Krauss in the Rittenhouse trial, that you should just, everybody takes a beating sometimes. Well, it might not be a beating. It might be a murder. It might be, worse. So I don't like this as our, standing. I don't think it is a purpose dangerous to the public peace. And again, this is my view of how the law should work. It's not what the law says. The law disagrees with me on this. But I don't think that a woman who wants to repel an attack on her person is dangerous to society. I don't think that is a societal concern. I think that, in fact, the societal concern is that she might be attacked and not be able to defend herself. And, that somebody might do something, horrible to her. I am more worried about that, to be honest. And I think that our courts should be as well. I will note here that we have that the members of the Supreme Court who are making this decision are people more like me than like the average homeless person, in the sense that they enjoy a, feeling of security that is brought by wealth and comfort and status. I mean, if you go to the Supreme Court, and I have, you go through metal detectors. There's security, there's sheriffs there present, right? They can feel pretty safe in what they do. And I'm pretty sure that the members of the Supreme Court are, can reliably expect that they're going to get police protection, and in a way that maybe a homeless person doesn't. So, they have no need potentially to carry a weapon because they have other people who will do it for them, you know, but, the old joke is, why do you carry a gun? Well, because a cop is too heavy. But the people making these decisions that you can't carry a weapon they're not, physically carrying a cop, but they're doing the next closest thing. They can rely on having one at hand at pretty much all times. I would love to see more people, in the courts who have experienced that kind of hardship. And I know it's probably unrealistic to say we need more people who are previously homeless, but knowing what that fear is like, in terms of having to walk home in a dangerous neighborhood late at night, and, what does it feel like to be mugged? These, I think, are really questions that I think need to be grappled with, because a lot of these decisions are being made from people who have a certain sort of security privilege that is not experienced by the average member or the most marginal in our societies. And that's who really gets hammered by these. Homeless people who get hammered all the time for carrying knives, and really they just don't want to be, they don't want to have their ribs kicked in by somebody who just thinks it's funny because they don't think of homeless people as people. Anyway, that's probably way more rant than I needed for this one, but it is, it's something that bothers me, especially when we start, looking at self-defense and how it intersects with, these issues of power and wealth and so forth, and who gets to make these calls. All right, carrying on here, because, yeah, this is already a long video and my ranting doesn't make it any shorter. So furthermore, I find no justification for the Court of Appeal's affirmation that the act of concealment rendered it more likely that there would be a breach of the peace. In effect, I find this reasoning to be rather counterintuitive. The Court of Appeal also held that concealment contributed to an already dangerous situation of which the respondent was fully aware, and evidences the respondent's choice of reprisal over deterrence. With respect, these are findings of fact which are not consistent with those of the trial judge. Remember what I said about they're not supposed to appeal on the issue of findings of fact? The other thing is that appellate courts are not supposed to readily substitute their belief on facts for the ones of the trial judge, because the trial judge actually heard the evidence. The Court of Appeal only gets transcripts. So they get a much more sort of sanitized version of things. And so the courts they don't like that when they're substituting facts. So carrying on. With respect, these are findings of fact which are not consistent with those of the trial judge and which appear to be unsupported by the evidence. To the contrary, the evidence reveals that Kerr possessed the weapons for a purely defensive purpose. Concealment was an obvious choice in the penitentiary setting. I mean, of course, right? He can't walk around with a shank on his belt because the guards are going to take it away and throw him in the hole. And, I mean, that one was kind of a head shaker, right? All right. Application to the present case. The Edmonton institution was a dangerous place. It provided a volatile environment in which most inmates possessed homemade weapons, and violence among inmates was commonplace. The Indian Posse gang, of which the deceased was a member, essentially controlled the penitentiary through intimidation and assault. The day before the altercation in question, both the deceased and another member of the Indian Posse issued threats against Mr. Kerr, the former telling Kerr that the guards would find him with his head smashed in, and the latter telling Mr. Kerr that he should not be around the next day. The following morning, Kerr, anticipating an attack, retrieved two weapons which he had hidden under a sink, a metal knife, and an ice pick. The deceased arrived in the servery in the company of 5 people, 4 of whom were known by Kerr to be members of the Indian Posse. Kerr knew that members of the Indian Posse did not necessarily fight alone. The door to the servery was then closed. I mean, this is like some movie shit here, right? He's been threatened. 5 guys all come in together. They close the door. He's cornered. Like, this is basically a scene from a movie here. The ensuing altercation between Kerr and Garin was extremely brutish, each party stabbing wildly at the other. Ultimately, Garin was killed by a stab to the head. The trial judge found that Mr. Kerr possessed weapons regularly, but for the purpose of this case, we are concerned with the possession in the context of the accusation of murder on the specific occasion of the altercation with the deceased. And so it's worth noting here that had they found him with these weapons on any other day, they would have had no hesitation in convicting him on this. None whatsoever. It's just this particular day. And this particular day, he had a better reason than most days to have the weapons. Justice Binney points out that the trial judge found that on the day in question, Mr. Kerr possessed weapons in part of his usual practice and part preparation for possible defense against aggression. According to Justice Binney, this usual practice reveals a more general purpose on the part of Mr. Kerr to use his weapon in the violent resolution of disputes within the prison population, and this purpose justifies a conviction under Section 88. With respect, I cannot agree, and this for 2 reasons. First, while the trial judge found that Mr. Kerr's possession was part of his usual practice, he made no findings as to the purpose underlying this usual practice. It is speculation to suggest that Mr. Kerr's purpose was to use the weapon to resolve with violence any dispute that may arise, as opposed to, for example, to use the weapon only to thwart an attack on his person. I mean, if he's going to stab somebody because he wants their pudding, that's a very different thing than if he's going to stab somebody because they're trying to stab him first, right? So second, if the purpose underlying Mr. Kerr's usual practice was strictly to repel whatever attack he may encounter, then this general purpose conflated with the specific purpose on the day in question. A specific defensive purpose to thwart a specific attack surely cannot be segregated in the human mind from a general defensive purpose to thwart any attack. That said, if Mr. Kerr were charged with having committed the offense on any other day, the result may very well have been different, either because his purpose on that day would not necessarily be strictly to repel an assault on his person, or because even if his purpose was such, the assault which is anticipated would not necessarily be unavoidable. So even in the context of a very dangerous scenario, they're saying, no, you've got to find some other way to deal with this. In my view, on this specific occasion, Kerr did not possess his weapons for purpose dangerous to the public peace. I agree with the trial judge's finding that Kerr possessed his weapons on the day in question for the purpose of defending himself against an imminent attack by specific individuals. I find that his purpose was not, in all the circumstances, dangerous to the public peace, since the attack was clearly unavoidable. Mr. Kerr was subject to credible threats of an imminent assault in an environment from which there was simply no possibility to escape, and in which, as was found by the trial judge, it was futile to seek protection. Because, if he goes to seek protection, what they might do is throw him in, protective custody, which is probably going to be him alone in a cell, which is really bad for your mental health. But the other thing is, if he goes and talks to the guards about, hey, these guys want to murder me, well, now he's going to get identified within the prison as a rat. And all that's going to mean is that everyone's going to want to murder him instead of just this specific dude. So, yeah, it's not going to help. It is also particularly relevant that the trial judge specifically found that Mr. Kerr's actual use of the weapon constituted justifiable self-defense. I mean, it might have been a very different scenario on that self-defense argument if Mr. Kerr had produced his weapons first, right? As was suggested by the Court of Appeal. Okay, yeah, you can see. I find that the reasoning on this in places from multiple justices gets to be pretty artificial. But yeah, carrying on. One might ask what the difference is between possession of a concealed weapon on a daily basis to defend oneself, if need be, especially in a dangerous place, and possession to deal with an imminent threat. I think that in the first scenario, the purpose is inconsistent with the duty to avoid violent confrontation by escaping, asking for police protection, or even negotiating. You hear that? You're supposed to negotiate with the muggers or the, killers or worse. There's words I want to use, but YouTube does not like them, so I'm just going to avoid. But you can read between the lines. I mean, I don't think that carrying a weapon is necessarily inconsistent with that. I mean, you can have multiple fallback plans. My first plan for avoiding a grease fire in my kitchen is to be careful about how I cook. But my second plan for that is if a grease fire happens, and I definitely don't want a grease fire, but, then there's the fire extinguisher. You can have all sorts of goals of avoiding confrontation and just have multiple fallback plans. I've got airbags in my car, and it's not because I plan to crash into stuff. It's because bad things sometimes happen, even though you really, really don't want them to. Like, I really, really don't want to crash my car into anything. I like my car. It's worth money. It would be difficult for me to replace, and any collision endangers my safety. There's all manner of reasons why I don't want to get into a car crash. And I will do a lot to avoid getting into a car crash. But I still have airbags, and I would still, if my airbags were defective, fix that real fast. Same with the seat belts. I would still fix that real fast, not because it's my primary means of of dealing with something in the road. It's not like, oh, hey, there's a rock in the road. I'm just going to crash into it because I got these airbags. This whole manner of thinking, I think, is one I can't agree with. So it reflects a willingness to engage in physical conflict if confronted with a weapon, or it reflects an understanding that sometimes you aren't given any choice. This purpose is contrary to public peace. On the other hand, possession in a particular situation on a particular day to meet an immediate threat to one's life with no real opportunity of avoiding it is such a purpose that is not a threat to public peace as such. So, lots of people are attacked but would never have met that criteria. So the conclusion that Kerr is not guilty on the charge at issue is certainly not to suggest that his possession was completely legal. Kerr would likely have been convicted if charged under Section 90 of the offense of possession of a concealed weapon, which they didn't charge him with. And so the court is saying, should have charged him with that. Moreover, the Corrections and Conditional Release Act contains provisions prohibiting the possession of contraband. This case is concerned squarely with the legality of Kerr's possession with respect to a particular offense. So they could have charged him with some other stuff, and that would have been fine. Before concluding, I wish to re-emphasize that, as discussed above, a purpose under Section 88 is any result which the person knows will probably flow from his actions. Thus, a defensive purpose will not mandate an acquittal, even where the assault anticipated is unavoidable, if that purpose is coupled with a second purpose which the person knows will probably result from his possession, and which, in fact, is the danger to the public peace. For example, a person's possession may, to the person's knowledge, likely result in mass panic or in a public brawl. This issue, however, does not arise on the present facts and should be left for another day. So there's even more uncertainty in terms of, self-defense and carrying of weapons. So conclusion, for the foregoing reasons, I would allow the appeal and restore the acquittal on the charge of possession of a weapon for purposes dangerous to the public peace. All right, and you're probably saying, thank God we're done, because we're in. We are done one set of reasons, and the dissent here I'm going to go over in some detail, and then we're going to really quickly skim the other reasons, because I don't want this to be too long, but I do want to cover in proper detail just how much of a mess this case is in terms of how many different thoughts. So Justice Binney says, I have read the majority of reasons of my colleagues Bastarash, LaBelle, and Fish. My point of disagreement with them, and therefore with the proposed disposition of the appeal, rests on the stubborn fact the trial judge found that the appellant had not a single purpose, but a double purpose for carrying his knife on the day in question, January 16th, 2000. I repeat for convenience what the trial judge actually said. Now, he's going to say this, and then he's going to go in a different direction entirely from what he says. So just fair warning, this is not actually the basis for his argument. Says there is no doubt that Mr. Kerr possessed weapons. He possessed them regularly, and on the occasion of January 16th, his possession appears to have been in part part of his usual practice and part preparation for possible defense against aggression. So it could be that, Justice Binney could have been saying, listen, he carried these all the time, so that's a reason for convicting him on this. That's him having these knives in prison is a purpose dangerous to the public peace, but he's going to go further than that. So we're going to start out here. The appellant's apprehension of a fight with Joseph Guerin on January 16th provided one purpose, but this is to be seen in the context of the appellant's more general purpose of carrying his weapon on this as every other morning of his prison life, subjectively contemplating the use of the shank in the violent resolution of disputes within the prison population. Or just maybe he doesn't want to get stabbed, so he's got to be able to defend himself against other people who want to stab him. So the evidence shows that in January 2000, the guards, and he's going to have a different framing of the evidence, so we'll see that here. The Edmonton institution had, to a significant extent, lost control over the inmates who had gathered themselves into warring gangs. The dominant gang was called the Indian Posse, which had about 30 known members in the Edmonton institution at the time, not all of them being of Aboriginal descent. Other gangs included a small white supremacist group, the White Aryan Resistance, various offshoots of the Indian Posse, for example, Native Syndicate, Manitoba Warriors, Saskatchewan Warriors, Alberta Warriors. I'm probably going to get demonetized for mentioning the existence of these groups, but oh well. And a small group called Death Do Us Part, whose members had graduated into serious criminal activity from youth detention centers. So various gangs. There was a hierarchy among the gangs, and differences were settled violently either by prearranged fistfights or fights with weapons. Following the killing at issue in this case, a guard was employed as the search coordinator, and in the course of a year found over 200 handmade knives, or shanks, among the inmate population. Prison fights were often precipitated by one inmate showing disrespect to another, which in prison jargon was called punking off. Under the code of honor observed by the prisoners, failure to retaliate for punking off would result in a loss of face. And you don't want that, because then people will start stealing your stuff, people will start viewing you as a target for violent offending. It's a bad thing. So living in such a violent environment, the appellant took care to arm himself. He always carried a shank during the day, and occasionally kept it with him in his cell at night. More often, he concealed his weapon at night under the sink in the kitchen where he worked as a cleaner. So, the question here is, what is the responsibility of an individual inmate in a situation where they've completely lost control and it's so dangerous to simply exist? So they say, we are therefore not dealing with a weapon carried for the purpose of an isolated instance of self-defense. Well, just as a thought here, assuming we take it as a bad thing that Mr. Kerr, would have been murdered, assuming we take that as a bad thing, and I do, how was he supposed to get a weapon if he didn't have one sort of as a regular thing? Like, is he just supposed to go down to the shiv shop and just pick one up? Like, do they think they're available at commissary? I don't understand how this, how this kind of flows here. The ultimate conclusion of all of this would have been that he shouldn't have had a weapon and he should have just been, murdered. So, yeah. So what is the public peace? And here we're going to get into some really interesting notions of what society should look like. So they say the foundational notion of the public peace reaches back to the roots of Anglo-Canadian history prior to the Norman conquest. A self-respecting Anglo-Saxon king would always try to bring order and tranquility to his people, and in Ethelbert's laws there was already one principle by which kings could extend their influence. Because that's a thing we think is a good thing nowadays, that kings extend their influence, right? That was the principle of the peace. The mitigation of the disastrous effects of self-help was attained by the extension of the idea of the king's peace and the responsibility of all, not just the parties in a quarrel, to see that it was observed. And they say the general purpose of the peace was to reduce the resort to violence. The Crown developed the scope of breach of the king's peace in order to preserve public order. Carrying on, he says, the concept of the public peace thus aims at a state of order, the very opposite of a state of violent confrontation, and is not much concerned with who is the aggressor and who claims to be defending themselves. Oh yeah, this is going in some bad places, I think, and I'm going to explain, or I'm going to give my thoughts on just how bad. So they say, breach of the peace, as a technical expression, has a narrower meaning than the breach of the Queen's peace, which is supposed to underlie every crime. The most flagrant instance of a breach of the peace is a riot. So also a fight between two or more parties is a breach of the peace, and both parties may be arrested, for the arrestor does not have to decide the merits of the affair. Now, the arrestor doing that is different than, than somebody being convicted, right? Because somebody who's being arrested doesn't necessarily have to arrest on the correct information, just on their subjective impression. So if they think two people are involved in a fight, they can subjectively arrest, they can arrest based on their reasonable beliefs about what's going on there. And I'll probably end up doing a video on citizen's arrest at some point, but yeah. They say, if no one could be restrained of his liberty in case of mutual conflict, except the party who did the first wrong, then and the bystanders acted at their peril in this respect, there'd be very little chance of the public peace being preserved by the interference of private individuals, nor indeed of police officers, whose power of interposition on their own view appears not to differ at common law from that of any of the king's other subjects. So again, we're getting into this weird conflation of conviction versus detention and arrest, which I think is a mistake in the sense that it's a very strange thing. So the court noted with approval that violence is of the essence of a breach of the peace, and affirmed that the reasonable apprehension of imminent danger of a breach of the peace justifies arrest not only by a police constable, but by the ordinary citizen. So, but when they talk about this in terms of, being not much concerned with who is the aggressor and who claims to be defending themselves, and that they don't have to decide the merits of the affair, well, that seems to be something that I think most people would have a problem with. Most people would have a problem with this notion that of an equal footing between, a healthy 20-something mugger and an 80-year-old in a walker who's got punched in the face. Those two people are not on equal moral ground. They're just not. The woman and her pursuer are not on equal moral ground, and I categorically reject any moral statement that says that they are, on equal ground. That that the use of force by, the 80-year-old victim of an attack is equal in, a moral sense, or should be equal in a legal sense to the precipitating attack that required that use of force. I can't get there. It's just, that's a no from me. So see also a case Frey and Fedoruk. So they cite that, and they note, or just as Binney notes, the existence of warring armed camps within a prison is antithetical to the whole concept of public peace. Yes, but once you let it get there, the whole point isn't just to let people murder each other to death, especially because a lot of the people who are the victims of this are going to be the people you think are least deserving. But anyway, the inmates' purpose in carrying their handmade weapons was to enable them to inflict harm or death on other inmates, whether by way of defense or otherwise. And I do think that the defense or otherwise is an important distinction. One can assume that each of the 200 inmates who yielded up shanks during searches of the Edmonton institution would all have pleaded that they carried weapons needed for self-defense. Of course, we don't necessarily have to agree that that's the case for all of them. Had self-defense indeed been everyone's paramount preoccupation, one would have expected that there would have been a state of peace guaranteed by mutual deterrence, but violence was endemic in the Edmonton institution. Acceptance of defensive weapons in prisons would have implications outside as well as inside prisons. Here we're getting to another, this is the scariest thing that they can think of here. The prospect of the general population arming itself purely for defensive purposes to protect life and property would carry us back, in terms of self-help, to the type of violent society in which the concept of the public peace was designed to eradicate. The argument that violent self-help in breach of the peace can be justified as a necessity has been rejected since medieval times as inimical to public order and should not be given new credence in 21st century Alberta. Well, I'm sorry, but the notion that, the 80-year-old walking home should just have to take a beating is one that I reject as well, and I find quite medieval, especially if we're if we're saying that it offends the king's peace. You don't get to make the argument that it's taking us back to medieval times. I don't think most Canadians would accept this notion that violent self-help is always improper. If we are talking about situations where somebody has defended themselves against a violent criminal, somebody who is working at a gas station late at night and somebody comes in and tries to, shoot them in order to take the money in the till, I don't think that they would be upset if that gas station owner, threw something at the, the guy with the gun. I think, in fact, that they would be quite upset if the law charged that gas station owner for that use of force in response to that aggression. People would find that offensive to their sense of morality, I think. And maybe I'm wrong. Let me know in the comments below if you disagree with me. But, I don't think that people just occasionally have to take a beating. And I know I'm really kind of ragging on ADA Krause here, but that was such a dumb comment. So the previous evening, the appellant had refused a request for coffee from a couple of members of the Indian posse, including the eventual victim, Joseph Guerin. This refusal was apparently interpreted as punking off, and retaliation against the appellant was both threatened and expected. The reality was that carrying his dangerous weapon on January 16th was a prudent course of action on the part of the appellant, but prudence did not make it lawful. No, he should have just gotten stabbed to death. The evidence previously set out makes it clear that the appellant would have been carrying his knife on January 16th, irrespective of the threats from the Indian posse, because he could be stabbed to death on any particular day. Now, I get that this is a problematic set of circumstances, but yeah, it's I'm torn on this one. I'm a lot less torn on the woman walking home late at night. So certainly it is open to a prisoner facing charges arising out of a particular knife fight to plead self-defense, but in my view, the underlying offense of possession of a weapon for a purpose dangerous to the public peace is not thereby defeated. Were the appellant to be convicted of the charge under Section 88, the specific circumstances of January 16, 2000 would of course have to be taken into account in the matter of sentencing. The appellant found himself in an appallingly difficult position, that of course the court wants to make even more difficult. It was open to him to seek protective custody, but he decided that he could not really expect much assistance from the prison authorities. The prison authorities can refuse protective custody. And also, if he gets protective custody, other people can decide to kill him later. That would put a target on his back for the rest of time. So he testified that the guards were not in a position to protect him, and this explanation was accepted by the trial court. The trial court agreed with that notion, which ruled that his plea of self-defense to murder was justified. A conviction of carrying a weapon under Section 88 would have been considered in that light for purposes of imposing a fit sentence. So Justice Binney would dismiss the appeal and would have convicted on the possession of weapon for purposes dangerous to the public peace. Now we get to Justice LaBelle, who you think I might be more inclined to agree with. Let's don't get ahead of us. Get ahead of yourselves here. So I've read the reasons of my colleague, Justice Bastarash. While I agree with his disposition of the appeal, I remain in disagreement with some aspects of his analysis of the applicable principles. In my opinion, the jurisprudence supports the view that the accused purpose in Section 88(1) of the Criminal Code must be determined wholly subjectively. Rather than mire the analysis in a needlessly complex subjective-objective approach, which I agree with, it is complicated and confusing, I would suggest simply defining a purpose dangerous to the public peace as the intent to do harm to persons or property, or being reckless in that regard. Of course, harm need not actually ensue from the possession of the weapon. Finally, the applicable defense under Section 88(1) is necessity and not self-defense. I will discuss each of these issues in turn. Now, you might think, the intent to do harm to persons or property is a really good standard for this, right? You might think that, okay, this sounds like more flexibility in terms of being able to defend yourself. That's not at all where he's going. And actually, I'm not actually sure. I said he, but I'm not actually sure about any of these justices because, yeah. So constitutional considerations aside, it is a common law presumption that absent a clear expression of parliamentary intent, a person is not liable for a criminal offense in the absence of subjective mens rea. It is not for this court to enlarge the scope of criminal liability under Section 88(1) beyond what the words of the offense will reasonably and properly bear. It is well established that when attempts at a neutral interpretation of a penal provision leave a reasonable doubt as to its meaning, any ambiguity should be resolved in favor of the accused. Now, somewhat hilariously, they cite the case of the Queen and Hasselwander here. And I'll cover Hasselwander at some point. I don't like Hasselwander. And I think Hasselwander is an example of them doing exactly the opposite of what they're saying that they should be doing here. Because in my view, in Hasselwander, they actually reached outside the definition in order to basically create new liability that wasn't there before. Yeah. Hasselwander I'll add to my list to try to cover sooner rather than later. This court has not extensively considered the requisite mental element in Section 88(1). In the Queen and Cassidy, it would appear that this court held that Section 88(1) requires that the accused subjectively intended a dangerous use. So, and I'm skipping over a lot here, and I'm going to be skipping over more than in previous reasoning, just because we want to get through this before I hit the 2-hour mark. A review of other cases demonstrate that the requirement of a subjective intent is the prevailing view. Relying on the case of the Queen and Flack, the court held that the crucial question is whether the Crown had proven beyond a reasonable doubt that the appellant had the intention of using the rifle for a purpose dangerous to the public peace. This follows from Justice McFarland's decision, or Judge, decision in Flack at page 59, or paragraph 59 rather, that it will be apparent that the intention of the appellant is the essential matter to be proved by the Crown in order to bring about a conviction for the offense charged. And at paragraph 61, the test is not the alarm or fear in the minds of the men in the camper, but the purpose and intention of the accused. And that makes some sense, right? Because if you're thinking about purposes dangerous to the public peace, let's say you are going out to trim some brush in the backyard. And I've done this. I had a tree that was obstructing the view from when I was trying to back my car out. And so I went out with, a big old blade and was trimming the tree. Now, a neighbor saw me and had no issue with what I was doing because he could see that I was trying to trim the tree for making it safer to, back my car out. But let's say my neighbor was a little more of a panicky person, a little more anxious. And they'd gone, oh my God, look at the big knife he's got. And had called the police. Well, that doesn't make my purpose dangerous to the public peace. My purpose is I got to trim the tree. And, the appropriate tools for doing that might look scary if somebody doesn't sort of think about what's going on. That, to my mind, is a much better and more predictable test, right? Because if we want to know, if I personally want to know how to regulate my behavior in terms of I want to stay within the law, then ideally that should be something that's within my head and not within the head of some judge who's later going to be reviewing it, because that judge later might say, well, you should have known that people would get scared of, the big knife that you're using to clear this out, especially because judges aren't always living in the same sort of experience framework of the people they're dealing with. And so they may not understand that things are reasonable. One of the first cases I covered was a big, long decision about whether or not it was reasonable, like whether or not it was crazy for knives to lock open, which is, of course, a really critical safety feature for a knife. And, the first judge that looked at that had taken the view that that indicated that this was a weapon. And the second, or the court sort of ultimate determination on that was thankfully from somebody who had some experience with knives and was able to point out the various safety issues that arise. So that kind of distinction to me becomes very difficult to know what you can and can't do, because you're ultimately trying to guess who your judge is going to be later down the road. And that's not ideal. So the elements of the offense must be distinguished from the evidentiary problems that arise in any offense where the trier of fact is called on to determine the subjective intent of the accused. No earthly judge can enter the mind of the accused. Rather, one must look at externalities or objective indicia of an accused state of mind. Again, that takes us back to our example of going duck hunting in Bob's house, right? This is, some of the other justices had said, listen, how do we know what goes in, how do we know what the person's subjective intent is? Well, the same way we know for all other offenses that have subjective intent. If I say I'm hunting ducks, but I'm in the house of somebody who is known to be my enemy and I'm shouting threats against him, then I'm probably not actually hunting ducks, right? You can determine what my real intent is. That's all this is saying. So references to a subjective test could lead to an idea that the evidence of an accused man as to his intent is more credible than his evidence of other matters. It is not. He may or may not be believed by the jury. Whatever he says, they may be able to conclude from the whole of the evidence that beyond doubt he had a guilty mind and a guilty purpose. I mean, that is the job of a jury, right? But always the questions are, what did he in fact know, foresee, expect, intend? And this is a question we ask of juries all the time, in terms of what their purpose is and so forth. If somebody is accused of possession of drugs for the purpose of trafficking, you'll have to sort of listen to the person's explanation and consider, is this a reasonable explanation or is it BS? And juries and judges and justices are more than capable of doing that. So a purpose dangerous to the public peace needs to be given concrete content. Within the meaning of Section 88(1), it is the possession of a weapon with the intention of doing harm to persons or property, or showing a reckless disregard for harm to persons or property. To be clear, Section 88(1) requires that the possession of a weapon coincide at some point with the intention of using that weapon to harm persons or property, or being reckless thereto. There must be at some point a meeting between those two elements. It is not a possession simpliciter offense. It requires possession coupled with an additional intention, but it does not require actual use of the weapon, right? So, if you're planning to go murder your neighbor, your possession is a purpose dangerous to the public peace, even if you don't actually murder your neighbor or even, get started murdering your neighbor. Criminal liability under Section 88(1) thus applies not only to an accused who intends to do harm to persons or property, but also an accused who is aware of a risk to harm to persons or property and persists with his or her intention despite that risk. Now, here's where we're going to get into how this justice would also shut down self-defensive carrying of a weapon. The normal state of society is the absence of harm to persons or property. Fair enough. The concept of public peace seems very much an old concept from the time that common law offenses still existed. Understood in the context of the modern criminal code, it is difficult to imagine that the public peace could be endangered by something short of harm to persons or property. This court considered the definition of peace, or king's peace, in the classic case of Frey and Fedoruk. In determining whether an officer had falsely imprisoned Mr. Frey for a breach of the peace, the majority rejected a definition of breach of the king's peace that was given infinite and overbroad context. And so they say, to us, a breach of the king's peace may seem to cover every possible crime. And they're rejecting that implication, right? All right, so they say, Watkins held for the court that there is no breach of the peace unless an act is done or threatened to be done which actually harms a person or, in his presence, his property, is likely to cause such harm or put someone in fear of such harm. That seems reasonable, right? In terms of breach of the public peace. However, they say, I see no principled reason why a similar definition with the incorporation of recklessness should not apply to dangers to the public peace. However, so you might be thinking, hey, this allows for a fair bit of self-defensive carry. I like this. You're wrong. So Justice Claxon found that the Crown's case is that the accused went to B Unit's servery on January 16th, anticipating an attack by Mr. Guerin, and armed himself to meet that challenge. On the principles I've articulated above, Kerr possessed the weapon for a purpose dangerous to the public peace. He intended to use them to harm another person or persons. The elements of Section 88(1) have been made out. Before criminal liability may be imposed, one must assess whether Kerr had a defense at law. So this initially starts sounding like that the justice is going to say, hey, listen, self-defense is fine. But it's clear that Justice LaBelle's interpretation here is that breach of the public peace would include lawful self-defense. So if you are intending to defend yourself lawfully against dangers, that would still count. And that the only argument that they're saying is allowable here is a necessity defense. And necessity, I'm not going to get into in too much detail, but it's a hard sell. So this would also shut down the notion that you could possibly have a weapon for self-defense. In fact, to a degree that's even more so, even though it was criticized as this notion that that anybody could carry around a weapon at any point, I think this would have been even further the opposite. So, defense counsel argued at trial and on appeal that Kerr possessed the shanks for the purpose of self-defense and therefore did not satisfy the elements of Section 88(1). The lower courts have traditionally found that possessing a weapon for the purpose of self-defense negates the mens rea of Section 88(1), which is, I like that better than what they're doing here. In my view, however, the possession of a weapon for the purpose of defending oneself does not make that possession lawful. Self-defense does not vitiate the mens rea of an offense. Rather, it is a justification for conduct that would otherwise attract criminal liability. I would go further than this and add that properly conceived, it is necessity and not self-defense that would be available to an accused as a defense under Section 88(1). So, again, really shuts down this notion of carrying weapons. So they say, first, the defense of necessity is limited to situations of clear and imminent peril. Thus, necessity would not excuse the possession of a weapon simply because the accused lived in a high-crime neighborhood or finds himself among a dangerous prison population. Second, the act must be unavoidable in that the circumstances afford the accused no reasonable opportunity for a legal way out, such as escaping or seeking police protection. And keeping in mind, whether or not the police actually protect you depends a lot on who you are and what your circumstances are. Finally, the harm inflicted must be less than the harm sought to be avoided. So he says that the defense of necessity is made out on these circumstances. And yeah, so if you thought I was going to like that particular set of reasons, you're not correct. Now, Justice Fish is going to he would allow the appeal, but on narrower grounds. Justice Fish basically says, and I'm going to really quickly summarize because this is getting real long. Justice Fish basically says, listen, the Court of Appeal stepped outside of that narrow aspect of looking at only questions of law, and that the question at the Court of Appeal, in fact, they say the conviction entered by the Court of Appeal largely rests, as we see, on a critical and impermissible conclusion of fact diametrically opposed to the trial judge's finding on that very issue. So essentially, Justice Fish would have said, listen, we should throw out the Court of Appeal's verdict and restore the acquittals, but only because they didn't have, this was not an appeal that they should have heard. They shouldn't have heard this appeal because it's an appeal on questions of fact rather than on questions of law. All right, so that's a whole lot of a whole lot of stuff going on there. And I know that this is a long video so far. This is one of those cases that, as I said, the Supreme Court had a real opportunity to provide some very needed clarity here, and they didn't. What we have instead is this decision that goes in 4 different directions. You get 7 Supreme Court justices and you put them in a room and you get 4 opinions on something that you and I are supposed to know to a certainty when, if we get into trouble. That's a bit of a difficult, it's very difficult to reconcile some of our notions of how the law works with how it actually functions when it ends up in a courtroom. And, this is frustrating, but ultimately the law remains the best way of addressing these, social conflicts. But I don't like this particular sort of line of reasoning here. I don't like where this gets us to. I don't like some of the court's views, in particular Justice Binney, who, again, seems to put a moral equivalence on people who I really don't think are morally equivalent, and I don't think the Canadian society would accept that. I will acknowledge I am more of a believer in self-defense because I have seen what it can do, particularly for marginalized groups who can't rely on police protection. I have friends who are, in various marginalized groups who are alive today because they were able to use weapons in self-defense. Some of them because, they live in the States. There's a woman I've lost contact with, but she, I knew her in my 20s, just online. And, having suffered a stroke earlier in life, she was not what you would call a skilled combatant. She had paralysis down one side of her body. She was not terribly mobile, but she was at one point attacked or, threatened with attack. They didn't physically lay hands on her, but they had made suggestions that they were about to by a group of people. And because she lived in the States, she was able to carry a handgun, and that resulted in the termination of that attack. They changed their mind about what they wanted to do, notwithstanding the fact that they had been very specific about their intentions in their comments in ways that YouTube would kick this video off the internet if I spelled out. She avoided that altercation because she had access to a weapon. And the Canadian answer to that is that she should have just suffered the consequences of that attack. And I cannot accept that. I can't. I don't view that as the appropriate result. I would not be happier with that result than with the result that happened. Orwell noted, and he was speaking in a more general sense, but he was talking about how weapons give claws to the weak. And that's really what they do. If you've got 6 people all in sort of fit shape, young and healthy, and you want to go mug some people, you don't necessarily need weapons. You can just surround some lone person, especially somebody who's smaller or older or vulnerable because of disabilities, and just, say, hey, give us your wallet or we're going to beat you down. And that'll be a pretty credible threat. They really sort of even the score for especially vulnerable groups, and the court specifically rejects the notion that people who are living in dangerous neighborhoods, for instance, should have a greater ability to protect themselves from those dangers. Well, obviously those neighborhoods are dangerous because of, people who don't care about the law. So the law in that case is really only restricting the vulnerable from protecting themselves against the dangerous. And I find that to be a problem. And I think that a lot of the people who advance these views in society if they extended these thoughts to the ultimate conclusion as to who this harms, and that's, minorities, be they racial, religious, LGBT people, people who are impoverished, all of these kinds of groups, is that really who we want to, to limit and harm? I hope not. So anyway, thank you for watching. I know it's been a real slog. Thank you if you've made it this far. This is an important case. It really illustrates a lot about how the courts think about self-defense, and there are some common principles that we see from the various different reasons. All of them basically hate the notion of the ordinary person being able to defend themselves in a meaningful way, with, access to some sort of weapons to make that possible. They just disagree as to how. So anyway, thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association and the CCFR. And at the $30 level, Sights and Arms Limited and Marc-Olivier Damour. At the $20 level, Peter Hilger, Mark Whittington, Jane Babe in Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and somebody I'm either going to have to give a refund to or ask them to change their name. I appreciate your sense of humor, but I don't know how YouTube would react to it. So, yeah, I'll be in touch. Anyway, thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.